Morning, class. My name remains Dr. Bello Mohammed Magaji, an Associate Professor of Law in American University here in Yola, Adamawa State. We shall be looking at a series of lectures on law of contracts, Law 201, week 1. Today we shall be looking at the topic Introduction to Contract Law. Under this topic, we shall be looking at 4 items. This includes definition and nature of a contract. We shall look at what is a contract and the nature of the contract itself. We shall look at some elements that constitute a valid contract under the law. We shall also look at the classification of contracts, under what categories are contracts classified. And then finally, we look at the sources of contract law in Nigeria. Now, let us start by looking at the definition of a contract. A very simple definition of a contract, as it is on the slide there, is that a contract is an agreement enforceable by law which creates legal obligations between parties. This is a very simple definition of a contract, and it consists of certain things that it has to be an agreement, it has to be enforceable by the law, and then it must create legal obligation. And of course, we must have parties to a contract. Now, that's the basic definition of a contract. Different authors in different books, you will see different definitions of contract, but there are certain elements that you have to look at in a definition which I have included here. Now, the law of contract is a branch of legal principles that governs the formation, interpretation, and enforcement of contracts. Basically, that is what is consists of the law of contract, which we shall be looking at as the course progresses. Now, of course, the law of contract provides a framework for parties to enter into legally binding agreements. As we earlier said, these agreements must be what? Enforceable. So it is a framework. The law of contract provides a framework for parties to enter into legally binding agreements. Now, we also say contracts are essential in various aspects of life, including business transactions, employment, relationships, and personal agreements. Every day you must agree, you enter into one form of contract or another. And then in various aspects of life, including business, employment, relationship, and so many things that you see yourself entering into what? A contract, an agreement as it were. And most of these agreements are what? Enforceable by the law. Now let us look at the statutory and case law authorities that supports our definition of what a contract is, as we have earlier mentioned in the first slide. Now we have 2 categories of authorities. We have the statutory authority, and then we have case law authorities. Now, under the statutory authorities, the most important law that governs or defines law of contract in Nigeria, for instance, is what we call Nigerian Contract Act, which is Cap C20, Laws of the Federation of Nigeria 2004. Under this law, everything about contract is contained therein. And then we say it provides the statutory framework for contracts in Nigeria. Just as I have said, everything you are looking for for contract, you will get it under this law. As I said, it is a framework for contracts in Nigeria. Now, the Act also outlines the essential elements of a valid contract, such as offer, acceptance, consideration, capacity, and legality. These are elements of a valid contract which we shall look at in more detail as the course progresses. But then, in the Act, it outlines such elements. Now, basically, that is the statutory word, authority for the definition we have given for the law of contract. Now let us look at case law authorities, that's what we call judicial authorities, as to what is a contract. Now we fall back on maybe one or two cases. The case of Khalil versus Kaboli Smoke Ball Company, with the citation herein, is an old case but often cited by Nigerian courts, which establishes the principles that a contract can be formed through an offer, acceptance, consideration, and also in cases involving unilateral contract. We shall look at Khalil's case in greater detail as the course progresses, because it's a landmark case, as it were, which goes to buttress the point of offer and acceptance in contract law. But then, as I've said, it's often cited, it's an old case, but it's often cited in Nigerian courts with great authority. Another case that goes to support our definition of contract law is the case of Union Bank of Nigeria PLC versus Ogbu. Is a case reported in 2005, and you can find it in Nigerian Weekly Law Report, part 920, page 1. Now, in this Nigerian case, the court held that a contract requires a meeting of minds, offer, acceptance, consideration. It emphasized the importance of consensus ad idem, that's meeting of minds in a contract, that's agreement on the same thing for a contract to be valid. Now this case supports the earlier definition of what we define as a contract within, as a judicial authority. Now, having said that, the cases, under Nigerian cases, it's an old case, the case of Union Bank of Nigeria PLC versus Ogbu. It's an old case, but it is based on Khalil versus Kaboli Smoke Ball Company, which is an earlier case, but they all go to support the assumption, the definition of what we have said is the law of contracts. Now let us, having looked at that, now let us look at the nature of a contract. Now the contract has certain basic issues, things that we attribute to a contract. One, consensual. Now we say contracts are based on the mutual consent of the parties involved. They are formed through offer and acceptance. And the Supreme Court has always been saying, we look at one or two of such cases, that parties are bound by their contracts. In effect, that parties are free to make contracts, mutual agreements to make contracts. But once they make this contract, the courts are there to do what? To enforce the contract. The second nature of a contract is that it is binding. Once a contract is validly formed by two parties, it creates legal obligations and rights for the parties involved. The third one is what we call, is private. The law of contract primarily deals with what? Agreements between parties, individuals or entities, rather than involving the state or public authorities. This implies that it falls within the realm of what we call private law. As we have said, it is an agreement between two parties. It is an agreement between two parties, and then the courts will enforce such agreements. Why we insist on this is that we say that it is not involving the state or public authorities, in the sense that if you enter into an agreement between yourselves and then there is a breach and so on, the state, i.e. the police, are not involved, because these are things that fall within private matters. But you see in Nigeria and some other places, people taking private contractual issues to the authorities. This is against the nature of law of contract. We say Another nature of a law of contract is that it is autonomous. Parties have the freedom to negotiate and determine the terms of their contract as long as they comply with legal requirements. We say parties have that freedom. As I've earlier said it, this is a Supreme Court ruling that parties are free to enter into a contract, mutual agreement, provided it is within the legal requirements. We can look at this in greater details also as the course progresses. Now, remedial. The law of contract provides remedies for breach of contract, such as damages or specific performance, or even to compensate the injured parties. We say it is remedial. If for any reason there is a breach of contractual agreement, parties can now resort to what? Remedies. These remedies can be in form of damages, specific performance, or compensation. This is a full topic which we shall look at in subsequent editions of our lectures. Flexible. Contract law allows for various types of contracts, such as written, oral, or implied contracts, such as as long as certain conditions are met. So there is flexibility. When we look at the various classification of contract, you will see that contracts form can be written, it could be oral, it could be implied, as long as they are within the provisions of the law. Now, the next thing we look at are the elements of a valid contract. Elements of a valid contract. This is very important for you to appreciate, to understand some of these elements, because they go and sum up to make a valid contract under the law. We have an offer, and then an offer, we have a simplistic explanation of an offer, but as I have said, these lectures are complementary to your books. The textbooks which I have already given to you, which I've uploaded in the Canvas, and some other lecture notes that I have uploaded. So you look at them to marry out, to feed in the points I'm making in here. We say an offer is a proposal made by one party to another, indicating a willingness to enter into a contract on specific terms. Fair enough. It is a proposal. We shall look at it when we come to in greater detail. Proposal made by one party to another. Now, when you make a proposal, somebody will accept. It now brings us to what? Acceptance. Acceptance is the unconditional agreement to the terms of the offer. It must be communicated to the offeror and match the terms of the offer. There is an offer here, we have an acceptance. You will hear us saying offeror and offeree as the lecture progresses. And then, of course, each of these offer will look at specific issues relating to offer. There are certain conditions related to offer, also acceptance. There are certain situations. That's why we say it is unconditional agreement. When we come to acceptance, you will see any variation from what has been proposed to you by way of you accepting it negates the what? The acceptance. So we shall look at that and the supporting cases in respect of that. Consideration. Consideration is key. If there is no consideration, you will lack the power to enforce the agreement in the court of law. What is consideration? We say it refers to something of value exchanged between the parties, such as money, goods, services, or a promise to do or refrain from doing something. Basically, this is what we call consideration. But in loose terms, when we say price, or since we have money here, the price of items, the money you receive, the goods, the services, it could not even be in terms of goods or services. It can be a promise to do or refrain from doing something. These are all consideration. We say again, it is a vital element to validate a contract and signifies that both parties have given something in return. Because in a contract, you have to give something in return, something proposed to you, and then you also give something in return. Now, we have also Another element of a valid contract, which is intention to create legal relationships. We say for a contract to be enforceable, the parties must have an intention to create legal relationships between the parties. There must be that intention. For instance, in commercial agreements, there is a presumption of intention to create legal relations, while in social or domestic agreements, the presumption is usually against legal enforceability. The point here is that most often in commercial agreements, definitely we assume that parties are intending that this agreement should be enforceable, should be legal. When you go to pick a car or to buy a product in a shop, it is a legal relationship taking place. But if you promise your wife or your son a car, say, okay, tomorrow I will give you a car in a more social, relaxed atmosphere, definitely the presumption is that it is not intended that it should be legally enforced. We shall look at this when we come to the topic of intention to create legal relationship. When we blow up this topic, we shall support it with legal authorities. There are some very serious cases. Balfour versus Balfour are all cases that go to support the presumption that domestic agreements may not be legally binding. Now, there are judicial authority also to that. Egbe versus Alhaji is a case reported in 1975 where the court held that parties to a contract must have a common intention to create legal relations. And this intention can be inferred from the conduct of the parties. You don't need to write, you don't need to do anything for us to infer that you intend that this relationship should be what? Should be legally enforceable. That is what the court held in the case of Egbe versus Alhaji. Now, the final one is capacity. Capacity relates to the ability of a person to enter into a contract independently. For instance, there are certain classes of persons that they will not be allowed to enter into a contract alone without some supportive element. We shall look at them. For instance, a child or an infant falls under this. He lacks that capacity, except with some exceptions. An insane person lacks the capacity to enter into such a contract independently. A drunk person will also fall. Importantly, also an illiterate will be supported by the act to enter into a contract. So these are all categories of persons which we shall look at every item we have said here with the judicial authorities and statutory authorities to support them. Thank you. Now let us look at the classification of contract. We have various classifications, and in your books you will see a lot of authors and learned authors have different classification of contracts. Some will classify them under express and implied contracts. Express contracts are those where the terms are explicitly stated either orally or in writing. It must be expressed that certain terms in the contract are what? Expressly stated. We have implied contracts which are based on the conduct of the parties or the circumstances surrounding the transaction. Now we have another classification that looks at it under unilateral and bilateral contracts. Unilateral from the word one person making a contract. As we've said, we'll look at the case of Khalil versus Carbolic Smoke Ball Company, unilateral, and then bilateral, when the contract involves other parties. Unilateral, as we've said, is a contract which involves a promise made by one party in exchange for the performance of a specific act by the other party. Bilateral contracts involve promises exchanged between the parties, normal promises that you exchange between parties. Another classification looks at it from executed and executory contracts. Executed contracts are those where both parties have fulfilled their obligations, whereas executory contracts are those where one or both parties are yet to fulfill what? Their obligations. Another classification look at void and voidable contracts. Void contracts are those that are considered invalid from the beginning and have no legal effect. Ab initio, from the beginning, they have no legal standing, no local standing, so they cannot have any legal effect. Whereas voidable contracts are initially valid but can be cancelled or avoided by one or both parties due to certain legal grounds. These are the voidable contracts, which from the beginning they are okay, but along the line some illegality came in that makes them illegal or make them avoided by one party depending on the circumstances. Finally, we have what we call unenforceable contracts. These are contracts which are lacking in some material details. For instance, in a very vital element of a contract, say consideration is lacking, the contract cannot be enforced. Contracts with illegal purposes. You enter into a contract to commit something illegal, definitely they cannot be enforced. Contracts with minors, as I have said, they lack capacity, so you must conform to certain legal requirements before they can be what? Enforceable. But as they are, if you enter straight away with a minor, they are not what? Enforceable. Well, contracts lacking, well, capacity, and contracts with fraudulent misrepresentation, these are all contracts that are what? Unenforceable under the law. Now, finally, let us look at the sources of contract law. There are so many sources from different authorities. If you, from the books I have uploaded onto your canvas. But then, let us look at some of the sources. Common law, you are aware, you know what common law is. That is, Nigeria inherited the English common law system, and common law principles form a significant part of contract law in Nigeria. So the very, very important aspect of common law, sources of contract law is common law. Common law is body of laws inherited by Nigeria by virtue of the fact that we were once upon a time under English law. Now, statutes, the primary legislation governing contracts in Nigeria is the Contracts Act. We have the Contract 1990. Now, this act provides rules and regulations regarding the formation, interpretation, and enforcement of contracts. But I must quickly also add that the whatever law we have under statutes come under the Constitution. The Nigerian Constitution 1999 as amended is the ground norm and contains certain laws therein that make it mandatory that every other contract law, any other law or statute that relates to contract must conform to the Nigerian Constitution. So please bear that in mind. I don't have it here, but I feel I should let you know. Now, case law, judicial decisions by Nigerian courts play a crucial role in shaping the law of contract. Courts interpret and apply the provisions of the contract and common law principles to specific cases, establishing precedents and guide future decisions. These are all case law. As we've even mentioned one or two of the case law that are all sources of contract law. Finally, we have customary law. In certain areas of Nigeria, customary law may also influence contract law. Customary law is applicable to parties who are subject to customary practices and traditions. Now, these are the sources. As I have said, there are various other sources of contract law, but these are the basic ones that I want you to acquaint yourselves with and read yourselves into it based on the lecture notes I have uploaded and the authorities or the authors I have given you. Thank you very much.